Hello everyone and welcome to my podcast, Human Rights, How Do They Stack Up? Where we explore different aspects of the legal system and whether they uphold or undermine human rights. With every episode there will be a survey attached in the description so you can feedback whether you liked it, whether there's anything you would suggest to improve, so please do fill that in once you've listened to the episode and enjoy! So hello everyone. Today we have Professor Padfield on the show, and she is a Professor of Criminal and Penal Justice and Director of the Cambridge Centre for Criminal Justice. And this episode is all about Article 6, so the right to a fair trial. And we're looking at what does a fair trial mean, and is this enforced in the modern day justice system? So firstly, Professor Padfield, I'd like to ask you, how do you regard human rights, define them, and their fundamental purpose?
Right, well, thank you for inviting me to talk to you today. It's an intriguing subject, and I've no idea how far we'll get in our discussions in a rather short time. Because, of course, these are huge issues that you're raising. How do I define human rights? Well, I guess I define human rights as simply being basic rights, which should be common to all of us. And we could get into a lecture about moral rights and legal rights. And, of course, in the world in which I work, which is criminal justice and penal justice, which is punishment justice, prisons, probation, and so on, there are really important questions about a fair trial, and they don't necessarily all boil down to human rights. We might want to try and discuss our fundamental moral values and things like that. But from where I sit, this concept of a human right is helpful in the sense that it gives us a simplified version of what are really, really difficult concepts.
That's interesting. So you think the idea, so Article 6 obviously falls under the Human Rights Act, but you believe it expands beyond that, this idea of a fair trial?
Hugely, hugely fair. Article 6 hardly scratches at the surface. You have to look at the history of it, I think, which is that Article 6 is part of the European Convention on Human Rights, drafted shortly after the Second World War, and it's very much lowest common denominator of what is acceptable. It was a rough and ready attempt in the late 1940s to jot down on the back of an envelope what's basic, but I certainly hope that I live in a country which has a lot higher standards than those very, very basic standards of Article 6. Article 6, don't get me wrong, I think it's really important, and I'm really, really glad that we've signed up to it, and I would be horrified if we unsigned up to it. It's really important, but nobody should think that you find within Article 6 a list of everything that's required for a fair trial. What makes a fair trial is really difficult.
I know you've just said it makes it really difficult to define what a fair trial is, but what would you regard as the key components to it?
First question I think I'd throw back to you is when you think the trial process starts. Obviously, many miscarriages of justice have gone wrong very early at the time of arrest, certainly when things go wrong very often in the police station. In a police station, there's obviously a huge imbalance of power where the police normally have the upper hand. But there again, clever criminals have really huge resources. So it is incredibly difficult to ensure fair play between the various parties to the process. And the right to a fair trial is, in part, ensuring a fair process.
I know you mentioned police. Do you think in our modern justice system, officials regard this right in the way it should be?
Well, I think you're talking about the police. I think the vast majority of police officers, of course, are good police officers trying their best in difficult circumstances to do a good job. Whether your average police officer is very interested in Article 6 of the European Convention on Human Rights, I rather doubt. I think police officers feel constrained by huge numbers of rules. Most of them are probably aware of a judge sitting on their shoulder, but whether they see this in a negative sense or a positive sense, I think is a really interesting question to think about. They know there are rules, whether they think they're rules which get in the way or whether they're actually rules which are really important to ensure that the process and the outcome is fair. You'd have to ask a whole load of police officers.
Hopefully that's something I can try and do. I'll see if that's possible. But
fantastic project for you to interview police officers on their understanding of the right to a fair trial.
Yeah, that would be interesting, actually. I'll think about that one. So, when one considers the rise of social media, would you say the concept innocent until proven guilty has been impeded?
I can only guess that what is behind your question is social media being used to publicise things pre-trial. And there are definitely questions about, for example, whether people's names should be published once they've been charged and before they've been tried. But I think even before we got on to discussing that, I'd want to explore with you what you understand, and indeed what I understand by the concept of innocent until proven guilty. Because, of course, when the police arrest you, they're not presuming that you're innocent. They've arrested you because they think you're probably guilty. And the presumption of innocence is a really, really important procedural safeguard. As I say, it's not something which says the police think you're innocent. It's that they've got to work on the presumption that you're innocent in order to safeguard your rights pre-trial. And I think there are very interesting questions as to whether pre-trial or until the moment of conviction, people should have the right to privacy. Is that what your questions involved? Because actually there are all sorts of other things in relation to social media and criminal justice. The huge increase in people's profiles on social media mean, for example, that complainants are looking through Facebook and saying, I think this is the person who assaulted me last night. And that is a form of increased private policing. And whether or not that's good policing, whether it leads to reliable identifications, and there's hugely interesting and complicated area of law which we could explore about identification. Many miscarriages of justice have happened because of misidentification. Even good, reliable, honest witnesses can be mistaken about who they're identifying. So certainly social media is changing the face of criminal justice in many ways. I'm not sure that I would agree with the premise of your question, which is that somehow it's impeded the presumption of innocence.
So it's kind of just changed the parameters almost of how we view it, would you say, rather than actually impeded upon the concept itself?
I don't know that it's changed the way we view it at all. Certainly the internet and social media has changed the world in a million ways, and there is just so much stuff out there. One of the big problems to a fair trial nowadays is disclosure of evidence. The defence has the right to know the material which the police have, not only the material which they're relying on, but the material that they have in their possession which they're not relying on, which might help the defence. And actually, there's so much stuff on mobile phones and everywhere. It's really, in practice, hugely difficult for disclosure to work fairly. So the internet, the rise of social media, has of course changed the face of criminal justice in lots and lots of ways, but I don't think it's affected the concept of the presumption of innocence.
One thing that I noticed you said was how innocence itself has a variety of, or at least to presume innocence has a variety of implications in and of itself. And one argument that I read that was very interesting was Owusu Bempa, who raises the argument that defendant participation should be voluntary rather than compelled. How do you respond to that notion?
Yeah, Dr. Owusu-Bempah is doing some fabulous work on defendant participation, and there are many issues about this whole issue, what we mean by participation, and whether you should have to play a role in your defence. One of the big issues is the right to silence, whether you should have to answer police questions. You and I probably would answer the police questions if we were asked them. But actually, that is an assumption that we can't easily make. I go back to what I said earlier about being in the police station. Power feels very much in the hands of the police. And even you and I would be pretty scared being interviewed in the police station. And there are many more defendants who are a lot more vulnerable in many ways, certainly, than I think I ought to be if I was in the police station, but I'm sure I would still be very, very nervous. So we do have the right to silence, and it's totally appropriate that we do have the right to silence. The big change, which I think you're hinting at, is the Criminal Justice and Public Order Act 1994 changes, which have allowed the judge to allow the jury to draw adverse inferences from silence in the police station. If at trial you rely on facts which you didn't mention to the police, the jury may be allowed by the judge to draw what's called adverse inferences. It's a fantastically complicated area of law, and many academics say it's a bad change. I'm not totally sure that it's so much a bad as in unethical change, but more so a problematic, impractical change. And it's resulted in so many complicated appeals and challenges to the law that I'm not sure that it's really worth the candle.
And when considering these kind of, I want to say, finicky bits of the law, so inferences from silence and that kind of idea of the different aspects that can affect your trial within the pre-trial phase, so police interrogations, from the point of arrest, basically, it's fundamental that the defendant actually has an actual comprehension of their situation. So with communication at its most advanced, would you agree that defendants do have access to all the relevant information necessary to defend their innocence? Long-winded question, but yeah.
And the short answer to your long-winded question is no. Of course not. You don't know the case that you've got to make against. When you're first arrested and the police only have to disclose very basic facts to you and your lawyer, if you have one, and everybody should, of course, have a lawyer with them when they're interviewed by the police, but you don't know what the case really is against you. So it's enormously important to give people proper legal advice in the police station. The reality is that many people who are arrested have also got a number of other difficulties. They may be drunk, they may be high, they may have mental health issues, and the system has to fall over backwards to make sure that people don't trap themselves through the scariness of the situation which they find themselves in. So there are many, many ways in which people need to be have their rights safeguarded when they are in the police station. There are far too many examples of things going wrong for us to be able to be complacent. And to go back to what you said about Dr. Owusu-Bampa's work, the whole nature of criminal justice can be extraordinarily unfair in that a lot of defendants come from such a different world to the world of the lawyers around them. Another book that you might enjoy very much if you've enjoyed her work is a book by Jessica Jacobson and her colleagues called Inside Crown Court. And it's a book which contrasts the two different worlds of the Crown Court, which are not the traditional worlds of the prosecution and the defence, but the world of the lawyers and the witnesses. And the witnesses and the suspects all belong in one world, and the lawyers and the judges live in another world, and those two worlds don't talk to each other very well. So we've certainly got to do everything we can to facilitate communication and strengthen the ability of suspects to understand the case against them.
How do you think we could go about that to enable a conversation between these two worlds?
It's a huge, huge question. And part of the problem is with our adversarial legal system, which does chuck parties against each other. And we have trial by jury, which has evolved over the centuries with complicated rules of evidence, which no suspect could ever be expected to understand. That's one of the reasons, again, why you need to have really good legal aid. One of the problems with our system is the huge cuts in legal aid in recent years. Legal aid gets a really bad press because people think of fat cat lawyers earning too much money. I can assure you that most lawyers working in criminal justice, and certainly those amazing duty solicitors who spend their time getting down to the police station, are absolutely not overpaid or indeed well paid. And yet the system depends on inequality of arms, as lawyers tend to put it. We need a system whereby suspects are well represented by lawyers, not only lawyers who are well paid, but paid for significant hours to invest in the job, because a criminal defence is not an easy thing that you can just put together on the back of an envelope. These cases take time, and we as a society have got to invest in the criminal justice system if we want it to be a fair one.
And considering legal aid, do you think it should be the responsibility of the state to provide that? Or is it a case of allowing private firms to handle legal aid?
Who's going to pay for it? I absolutely believe that if you're arrested, you should have the taxpayer paying for your legal defence. It would be an outrage if you, walking down the streets arrested tomorrow, had to dig in your own pocket to defend yourself. As far as I'm concerned, it's absolutely fundamental that the taxpayer should pay. Of course, we need to control costs, but costs can be controlled in lots of different ways. One of the huge expenses of the system now is badly drafted laws, which means that trials take too long because there are arguments about points of law or more appeals on points of law. There are lots and lots of ways we could save money. We could divert more people from the criminal justice system. Far too many people, in my book, are prosecuted who actually should perhaps be diverted to mental health services or restorative justice programs. There are all sorts of different ways of saving money within the criminal justice system, but not paying lawyers is not a good way of saving money.
And you mentioned the bureaucracy of the system, I guess, and How do you think it would be possible to kind of unweave all these knots that kind of come into your path?
I wonder which bits of the bureaucracy you mean. Probably you're still in the world of legal aid, and of course there are always going to be problems with any system which is means tested, merits tested. You've got to have checks and balances. You might, though, be talking about the Crown Prosecution Service, which provides a really good bureaucratic check on policing. And we've got to have what you might call bureaucratic checks and balances to make sure that the system is working. One of the things which makes our criminal justice system work, or indeed not work, is the discretionary powers of so many different players within the process, whether you're talking about the police or the Crown Prosecution Service or judges. And you've got to have systems which check that people aren't abusing these wide discretionary powers. I personally think it's really important people have discretionary powers. The law has to be flexible in order to be fair, but too much flexibility is really dangerous, leads to discrimination, and we can see lots of evidence of discrimination within our criminal justice system. So you've got to invest in bureaucracy, if you like, checks and balances to try and have as good a system as you can have.
I want to talk about the COVID-19 pandemic and how that's affected the criminal justice system and how it's running. So some trials have been occurring on Zoom, Skype. And do you think the pandemic as a whole has exposed any flaws within the criminal justice system in how it conducts fair trials? Or has it even highlighted some successes of the criminal justice system?
What a big question. Again, I could talk about this one for hours. It certainly exposed the huge damage of austerity in criminal justice. If we hadn't had so many court closures in recent years, we wouldn't have faced some of the problems that we've been facing. I think the pandemic has revealed many, many problems, but there's also been some surprises. Back last April, everyone, including the government, thought that they would release a lot of people from prison because of the risks of the COVID-19 in prison. Interestingly, they haven't released very many people, and we should all be desperately concerned about the state of our prisons at this moment. The Chief Inspector of Prisons last month produced a very worrying report on mental health problems for people in prison, locked in their cells for most of the hours of every day and night. Huge problems in the prisons. And the small decrease in the prison population, which we've seen in the last 9 months, hasn't been to do with people being released early, but to do with this absolutely dreadful backlog in the courts, which is going to be problematic for quite a long time to come. Now, one of the solutions on offer is video justice or digital justice, and I personally am really nervous about that. I think the right to a fair trial, when you're sitting in the prison and either your lawyer is sitting with you, which would be the best alternative, or on the end of a telephone in their own home or their office. There's a lot of work to be done. There's a small amount of evidence so far on the problems, or the practical problems and the legal problems with communication by digital justice. I think it's really, really important that we have face-to-face justice, that we have local courts dispensing local justice, that judges can actually talk to the people in front of them. And there's a danger we're going to rush now into more digital justice, but personally, I hope we don't. There are lots of other areas where there's been desperate underinvestment in recent years, and I think the pandemic has revealed that. One other very obvious area is the underinvestment in resettlement services for people when they come out of prison. So we've seen some attempts during the pandemic to house homeless people. Let's hope that the provision on providing suitable accommodation continues after the pandemic. But what we're also seeing is enormous numbers of people released from prison at, let's say, half time in their sentence, and then recalled because they're not complying with the terms of their supervision. And we've got to invest so much with support to ex-offenders, which isn't happening nearly as much as it should at the moment.
Because
that's away from the right to a fair trial where you started me.
No, that's actually really interesting. So there's almost this mismatch between prisons and the rest of society. So it's difficult for reintegration. Is that what you're referring to? So when people are released, they kind of struggle to conform back to regular societal norm.
It's a whole nother subject, isn't it? What is the criminal justice system for? What are prisons for? Now, I would argue very strongly that we punish people in order to reduce the likelihood of their reoffending. Now, if you want to reduce the likelihood of somebody's reoffending, you would not send them to most of our prisons to do the sorts of things that happen in our prisons nowadays. If you wanted to reduce the likelihood of reoffending, you support people, you help them deal with their disadvantages, you work out what their needs are, and it's a time-consuming, expensive process, building people's hopes, building people's chances to lead a law-abiding life. And we're not investing in the areas those areas nearly as much as we ought to if we really want to reduce reoffending.
It just highlights that fundamental need for communication along the whole process within the criminal justice system. Is there any literature you'd recommend for anyone listening? You've already recommended a book, but is there anything else you'd recommend for people who are wanting to learn more about what it means to have a fair trial and what innocent until proven guilty actually means?
If it wasn't the pandemic, I would strongly urge you and everyone to hang around in the criminal courts and watch what's going on. There are loads of ways that you can also volunteer within the criminal justice system, and I think that that is fantastically useful. Probably you're still under the age of 18, so it is quite difficult to encourage you to do many of the things that I would like you to do. Every prison has an independent monitoring board of ordinary people who volunteer, and I think IMBs are hugely important as the eyes and ears of ordinary people within the prison system. So I can't urge you to join an IMB, but do ask your parents, your teachers, all the adults that you spend time with, explore with them whether they wouldn't like to consider whether they had the time to volunteer for such responsibilities, because one of the problems about prison walls is they're really good at keeping people inside prison, but they're sadly rather good at keeping us all out of prison. So there is great, I think, public ignorance about the reality of prisons. And I'd go so far as to urge that to judges and magistrates too, that they should find opportunities to spend more time in prisons if they can. Of course, during the pandemic, all these things are really difficult. Reading, keep an eye on the Chief Inspector of Prisons, the Chief Inspector of Probation's websites, the NGOs like the Howard League for Penal Reform and the Prison Reform Trust. Prison Reform Trust produce wonderful Bromley fact files. There are some excellent websites which I would certainly encourage you to look at.
And just to clarify, what are IMBs? I've never encountered that before.
An IMB is an independent monitoring board. And every prison has an independent monitoring board of ordinary people who are appointed to. So here we don't have a prison in Cambridge, but we have Bedford, and we have High Point, and we have Little Hay, and we have Whitemoor. We have a number of prisons within an hour's drive. And each one will have a committee of about 15 people who are ordinary people, and they're not lawyers, they're not experts, but they are appointed, and then they have a duty to regularly visit the prison. They draw their own set of keys, they talk to anyone, they find out what's going on in the prison. They have an open door to the governor and they say, why is everybody on A wing so discontented at the moment, or whatever. And some IMBs are more effective than others. And again, we could have a long discussion about how you measure effectiveness. But I do think that if the general public can be interested in what goes on in prisons and indeed in courts and police stations, it would be really to the benefit of all of us.
Thank you so much, Professor Padfield. This has been an interesting interview, and thank you for talking with us. It's been fantastic, and I'm sure it's been an amazing insight for everyone listening as well.
Great pleasure.
Thank you.